Metropolis.
Yes,
Well, you have on your desks, Lady and Lords, a development of the document submitted by Mr. Bowen to you yesterday. Can I just explain to you how it's been developed? We have sought to add, in the interest of a more comprehensive picture, the provisions as related to Metropolitan police officers. So you can see that previously it was non-senior senior. You've got a column now for Metropolitan police officers tracing the history in relation to them. And then in relation to the next column, public complaints, you've got provisions that deal with special arrangements for public complaints, and there's a column that highlights those.
Yes.
That document is agreed with Mr. Bowen, subject to a couple of points that I need to make to you. It's not agreed with Ms. Monaghan, not because she positively disagrees with it, but because she hasn't had an opportunity to study it closely.
Well, no doubt she will have such an opportunity in due course.
Well, actually, I wouldn't blame her if she said that the lunchtime wouldn't be sufficient, because this is not a complaint against Mr. Bowen. We got the document, I think, on Tuesday, started the case on Wednesday. We're working, my learned junior, Mr. Crows, has been working on it, and Mr. Bowen's been very helpful in responding rapidly.
Well, you're not disagreeing with anything that was in Mr. Bowen's document.
That's right.
You're simply supplementing it by things that you think we should also be aware of.
There are a couple of other points that Mr. Bowen asks me to mention, and they're agreed points. The first is, as a broad statement, we agree that until 2008, the chief officer had the final decision in dismissal cases subject to appeal. By having the final decision, what is meant by the parties is either the chief officer was taking the decision to dismiss, or the chief officer had a power of review of a decision taken by a panel or tribunal.
And that's both senior and non-senior?
Well, that's non-senior.
That's non-senior.
I'll have to think about the position on senior. Sorry.
Well, it wouldn't be the chief officer.
With the seniors.
It would be the authority, wouldn't it?
That's right. So that was the first caveat. The second was slightly more nitty-gritty. If you've got page 2, on the right-hand side of the page, first of the boxes, hearing conducted by disciplinary tribunal, you can see the words decision taken to dismiss by chief officer or other officer. And Mr. Bowen asks, and I don't disagree, for you to add the words appointed by the chief officer.
Yes.
And the same point applies if you go to page 3, and in the third of the horizontal columns, final box, if you put a cross against that same point applies. And the same point applies again on page 4. Second of the horizontal columns, again, fourth main box. So you're right, my lady, we on this side did wish to draw attention to distinctions as far as the Metropolitan Police were concerned, but also to the complexity of the various arrangements according to the type of case and the rank of the particular officer, and to make you aware that in the 1970s, and under the Police and Criminal Evidence Act 1984, there was a procedure in respect of complaints by the public which went to a police complaints board, and then there were various complex arrangements. But I don't intend to go into the detail of it, just so that they're, as it were, on your radar. Lady Morris, can I then come back to our submissions?
Yes.
As you recall, we're on the subject of the case law relating to judicial proceedings immunity. I've taken you yesterday to Trapp and Mackey. I wanted then to take you briefly to Dawkins, Lincoln and Daniels, Christou, relied on by my learned friend Ms. Monaghan, and then Singh and Redding. Can we start with Dawkins? You have that in volume 8, tab 101, MS 2363.
to,
363.
thank you.
Just so that we're clear as to why I take you to the House of Lords decision, we looked yesterday at passages from the Court of Exchequer for two reasons. One, to highlight the broad application of the doctrine in terms of the nature of the bodies to which it was said to apply in Dawkins, and secondly, briefly to refer you to a passage on rationale. As far as the first point is concerned, you have it at 2366. I make this submission with half an eye on the question what would have been decided in the 1960s under the Race Relations Act, and looking ahead to Mr. Bowen's arguments on that point, but also in the modern age, looking at what the common law has said about the reach, the bodies to which this applies. And you can see that on 2366, the point was being argued, if you have, it's halfway down the page, the Court of Exchequer Chamber strained the principle of protection much too far by extending it not merely to military tribunals, properly so called, but to meetings of military men in what were really investigating committees, having nothing whatever of a judicial character about them. And you can, if you go to the bottom of the page, you can see, and then on to 2367, you can see the sorts of points that were being made about the Court of Inquiry. We saw some of them already in the Court of Exchequer's judgment, but it was being submitted not one of the requisites of the court, of a court applies to it, not established by law, nor recognised in the Mutiny Acts. The people are to make the inquiry of no juridical character or office. They have no settled legal jurisdiction. They're only persons nominated for the time being who may never have exercised any judicial functions, who may never again be called on to do so, and have not any judicial functions to exercise, so they decide nothing. They can only report their opinion to the authority. No established forms of procedure, can't administer the oath, can't compel attendance of anyone other than a military person, and that only by virtue of military obedience to the commander-in-chief, can't give judgment or enter it upon record, and in fact they are a mere assembly of officers without recognised legal status. Surely they don't have judicial proceedings immunity. The answer, as you've seen, is yeah, they do. And at 2372, the second point I said I'd remind you of on public policy, on rationale, at the top of 2372, but the principle we apprehend is that public policy requires that witnesses should give their testimony free from any fear of being harassed by an action on an allegation, whether true or false that they acted from malice. The authorities are numerous and uniform. In the present case, the defendant, a military man, was bound to appear. We draw some analogy between the situation in Dawkins, the military context, and the police context. In relation to Lord Reed's point, which I'm going to come back to in greater detail in a moment, on the question of compulsion, the interesting thing is compulsion seems to work both ways. So if you're compelled to attend, according to the House of Lords, then you should be protected from suit. But equally, if you're not compelled to attend, the law should encourage you to attend voluntarily and to give evidence freely. That's all I wanted to take from the decision of the House of Lords in Dawkins and Rokeby. May we go then to Lincoln's and Daniel. That's in A10, tab 122. And it's at page 2856. As the court knows, MS 2856. As the court knows, that's the case which held that an inquiry before the bench of an Inn of Court was a judicial process recognised by law. You'll be aware also that the argument against that proposition was that because the authority of the bench of an Inn of Court was not derived from statute but was based on centuries of practice, it could not be said that the process was recognised by law and that therefore judicial proceedings immunity applied. Now, I wanted to take you to this authority specifically for two reasons. Again, looking at the statement of the rationale conveniently set out from the Munster and Lamb case, but secondly, to come back to my point in answer to Lord Reed's question about the role of public interest in the outcome of the proceedings. The passage from Munster, as Lord Justice Fry, is conveniently set out at 2866. The rule of law exists not because the conduct of those persons or... I'm so sorry, my lady. It's halfway down the page. If you can pick out Munster and Lamb in the italics. So 4 lines down from the beginning of that paragraph, the rule of law exists not because the conduct of those persons ought not of itself to be actionable, but because if their conduct was actionable, actions would be brought against judges and witnesses in cases in which they had not spoken with malice, in which they had not spoken with falsehood. It's not a desire to prevent actions from being brought in cases where they ought to be maintained that has led to the adoption of the present rule of law, but it's the fear that if the rule were otherwise, numerous actions would be brought against persons who were merely discharging their duty. It must always be borne in mind that it's not intended to protect malicious and untruthful persons, but it is intended to protect persons acting bona fide who under a different rule would be liable. So that's the Munster and Lamb passage I wanted to remind you of. In our case, we refer you to Scott and Stansfield. I don't take you to it at this stage, but we refer you to it obviously because it refers to the position of judges. A lot of the cases, as you're aware, are cases about witnesses. Now, as to the point about public interest, if you would turn over to 2868, still in the judgment of Lord Justice Sellers, you can see, again, the relevant passages begin halfway down the page. There is comparison made with the situation in relation to solicitors, at least at that stage in Addis and Crocker. It's accepted by the Court of Appeal that no Act of Parliament governs the four Inns of Court, but their disciplinary powers over their members have been exercised for centuries and, as far as I know, have never been in abeyance. They're not solely or primarily exercised for the good government and well-being of the inns themselves, as is the case of private clubs or institutions, whose powers of control are derived from the consent of the members, but are enforced for the benefit of the public by these ancient legal societies in order to retain the trustworthiness and complete integrity of counsel and the performance of their duties in the administration of the law in its many phases. I draw attention briefly, if you have over the page 2869, to what were observed to be weaknesses in the case for judicial proceedings immunity, the penultimate paragraph. I'm not unmindful of some of the matters which attach to court procedure, such as the hearing of evidence on oath and the power to summon witnesses, which do not apply to an end of court disciplinary inquiry, but I do not regard these as vital to the present issue. And you will have seen in Heath, paragraphs 33 and 40, the Court of Appeal in Heath pointed out that in Lincoln and Daniels, as in Dawkins, the criterion of independence was not robustly established in the sense of independence from the organisation which appointed the members of the panel, and or independence from the particular profession in respect to which the decisions are being made. Can I go then with you to 2873 for further consideration of the point about public interest from Lord Justice Devlin, as he then was. At the top of the page, a private institution, such as a club, may set up a body to determine questions of admission or expulsion, and it may be composed entirely of lawyers and may follow with exactitude the procedure of a court of law. But absolute privilege is granted only as a matter of public policy and must therefore on principle be confined to matters in which the public is interested, and where therefore it is of importance that the whole truth should be elicited even at the risk that an injury inflicted maliciously may go unredressed. The public is not interested in the membership of a private club. The significance of the third requirement that the court or tribunal should be recognised by law is that it shows that the public is interested in the matter to be determined by the court. My lady, that passage, we say, supports the drawing of a distinction between a case where, under statutory procedures enacted by Parliament, specifically because it is considered that Parliament should retain control over disciplinary decisions, because that is in the public interest and or because of the peculiar position of police constables, is distinct from, putting it in very broad terms, a position where a private law position under a contract of employment. That goes also to Ms Monaghan's submissions on the distinction between a domestic tribunal, as it's been coined, and a quasi-judicial tribunal. Now, coming back to Lord Reed's question then, my answer, I'm afraid, isn't very different, but it may be slightly better expressed at this time of day. I do rely on the point about public interest as introducing a greater imperative, if I can put it in those terms, for those who perform those functions in the public interest to do so freely and without fear of personal liability.
But these are all cases about witness immunity, aren't they?
Well,
But certainly the discussion, the passages to which you've drawn our attention, are about witness immunity.
That's
now,
true.
it may be that the two
Yeah.
go hand
Yes.
in hand.
Yes.
It may be that they don't.
yes.
But there's a lot of discussion about the rationale for witness immunity
Yes.
in Jones and Caney,
Yes.
rather rubbishing some of these public policy considerations, as I
Yes.
recall.
Yes.
Despite having been in a minority in that.
My lady didn't wholeheartedly agree, that's right. And I'm not going to, as it were, pray that in.
I am loyal to the decision of the majority, as always.
Of course, of course. Well, I'm not necessarily intending to go to Jones and Caney, because you will know the case very well. But the point I make about Jones and Caney is that it's essentially accepted that in the case of expert witnesses, they had a duty of care to their clients, but that did not necessarily mean that they needed additional protection in order to ensure that they did perform their duty to the court. And I appreciate that some of the arguments that were put there along the lines that, well, people won't want to give expert evidence.
Yes, it was a different point, of course. But
I agree. I make the point about the public interest in the witnesses, but I do submit that there's no reason to distinguish that type of situation from the situation of the position of the individuals who are making those decisions in the public interest. All who are concerned in the process ought to be serving the public interest in reaching the right decision as to whether the officer should or should not be stripped of his office. Secondly, as to my Lord Reed's point about only a fool would be a judge, obviously not a point that my Lord would support, I hope. But
in the absence of immunity, then he would be a judge.
That's right. That's right. I do draw attention to this point, that of course it's not the case, even in relation to the disciplinary panels, that all three of the individuals are people who can be mandated to serve on the panels. I broadly accept that in relation to the HR person and the officer. But the independent MOPAC member is a person who has applied in response to an advertisement and or been interviewed with a view to deciding whether they should be on the MOPAC panel. It's broadly, in a position broadly comparable to the lay members of employment tribunals. Now, I'm not going to say, well, nobody will apply if you rule against us in this case, but that type of consideration is therefore in play, although I accept wholly in respect of all three panel members. And then thirdly, collateral attack, as discussed yesterday. I do say that given that a clear statutory route of appeal is provided, one of the rationales for judicial proceedings immunity ought to be that you should pursue the statutory procedure rather than seek to attack the outcome in the employment tribunal. And I submit, Ms Monaghan isn't arguing the contrary, although I don't say that precludes you from taking a different view, that those points all apply equally to the members of the panel and the witnesses appearing before it. My lady, may we turn then to the Christou case at A2, tab 18. MS 507. The core point that I seek to make in relation to Christou I've made already, which is to submit that there's a material difference between the situation where decisions are being made under the control of Parliament in a framework set out by statutory instrument for reasons of public interest, and the private law case, which I submit is a case of a domestic tribunal. But I make these additional points. Firstly, that Christou highlights the weakness of the analogy with the private law employment case, because of course under the private law contract of employment, the employer isn't bound by the decisions of its disciplinary panels. A CEO can ask for a member of management, for example, to be disciplined and then not accept the result and say, well, I'm going to terminate the contract anyway. A chief officer, rather like bishops under ecclesiastical law, needs to, in effect, to seek the permission of the disciplinary panel if there is to be removal of the constable's office. And if the panel says no, the chief officer can do nothing.
But that is presumably a feature of the. Obviously, you're obviously correct to stress there's a public interest in this particular context, but that feature is to protect the officers, isn't it?
So, which feature?
The feature that the chief constable is not able to dismiss without the permission of the panel is to protect the officers and give them a due process, which used to be even more stringent than it currently is.
Well, I wouldn't necessarily accept that. I would accept that in part it's to protect the officers, but it's also, I would respectfully submit, to protect the public, that the decisions are made.
You mean that the chief constable isn't sacking perfectly good officers?
Well,
for his own...
out of fear or favour, or not sacking them, as the case may be. Because as the passages we looked at from the Taylor Review highlight, the aim is to reach, as inverted commas, the right decision in the interests of all concerned. The third point I make by reference to Christou is that the Court of Appeal there was not directly concerned with judicial proceedings immunity. It was concerned with questions of res judicata, which bear a similarity, but in my submission aren't identical to the issues relating to judicial proceedings immunity. Fourthly, obviously, all of the observations of the court about the employer informing itself about as to whether it should or should not dismiss are observations made on the footing that there was a contract of employment. and it's accepted in this case that there wasn't, simply that the constables are deemed to be employees for the purpose of certain statutory rights. That's all I propose to take from Christou. May we move then to the case of Singh against Reading, which you have at A12. Tab 3724, sorry, tab 147, page 3724. Lady, I draw attention to Singh primarily because it has what the court may consider a helpful account of the law in relation to line drawing when it comes to judicial proceedings immunity. As part of my overall submission that the consequences are not as stark as my learned friends would argue, because whilst Ms Monaghan was submitting that the principle is a broad one, and I have accepted that it applies to a broad range of bodies, ultimately it's a principle which only bites on the decision-making process before the panel. Singh is a case where an allegation of discrimination / constructive dismissal was being made on the basis that colleagues of the claimant had been prevailed upon to give evidence adverse to her, and the argument was put, well, this is all for the purposes of an employment tribunal and therefore subject to judicial proceedings immunity. And the Court of Appeal held that whilst, of course, the tribunal process, the employment tribunal process, would have the benefit of judicial proceedings immunity, what had happened fell outside the scope of the immunity because, in essence, it was not part of the process, of giving evidence. Now, pausing there, as it were, as a side before we look at the authority, just picking up a point Ms Monaghan was making, I invite you to reject. She appeared to be submitting that judicial proceedings immunity or its application depended on how high up the judicial hierarchy you were. She was saying that obviously the Supreme Court would be protected, but lower down, as she was putting it, there might not be such protection. I'm not certain what she meant by that, but one has to consider what then is the position of the employment tribunals. They're lower down, as it's put, but obviously in my submission they would enjoy judicial proceedings immunity, and no one seriously disputes that. Can I just highlight then, rather than read you lengthy passages, because I'm merely saying that it contains a helpful account of the law, that at 3731 there are further statements of the rationale of the policy, and I don't repeat them given that I've made my submissions on that question. But if you go then to 3736, you can see what I submit is a useful account of the law, or very useful, I respectfully submit it. You will find a useful account of the law on, as it were, line drawing, the limits to the rule.
Paragraphs?
For example, 51 at 3738, the Darker and Chief Constable of the West Midlands case, it was going too far to say that the immunity would extend to acts to procure false evidence. And then if you have at 3739, paragraph 59, Roy and Pryor, at the bottom of the page, allegations of abuse of process would not be defeated by judicial proceedings immunity, and other examples, for example, bribing witnesses, are given. And then at paragraph 66, you have in my submission a very helpful summary of the law in relation to line drawing, page MS 3741. As I mentioned, I draw attention to those passages because I'm obviously seeking to meet the point that there will be dire consequences if we're writing this appeal. My submission at this stage is that judicial proceedings immunity would be limited to the actual process of decision-making and giving evidence in the course of that process. So, for example, Mr. Herbert, I think maybe here, Mr. Herbert's here. He expresses a concern, and in his submissions, that black and ethnic minority officers are vulnerable to being fitted up by trumped-up cases going into the disciplinary procedures. My answer to that, in part, is, well, of course, those who abuse the process or procure false evidence or make false allegations would not be protected by judicial proceedings immunity anyway. Well, that was all I wanted to look at by way of authority. May I then turn to my submissions on the application of those principles by reference to the 2008 regulations themselves, which, are, as you know, are A1, tab 5, MS 131. Well, I don't wish to obviously subject the court to a less than entertaining trailing through the regulations, but there are some points that I wanted to draw attention to.
It's going to be entertaining, is it?
I beg your pardon?
That exposition is going to be entertaining, is it?
No, it's not. So I want to keep it to a minimum, is what I was trying to say.
Yeah.
I obviously have to have, I have my own on two aspects of the argument. One is judicial proceedings immunity, but obviously later on in the debate between the parties, the question of procedural safeguards in relation to Article 6, the Article 6 type argument. So if you just bear with me when I highlight certain points. As to procedural safeguards, I point out in relation to suspension at 201 Regulation 10, I don't read the passage to you, that there are detailed specifications as to the bases on which the individual may or may not be suspended, which obviously have the force of law. Debate is obviously, there's a debate between the parties as to whether, well, it's much the same under disciplinary procedure. In my submission, it would be highly unusual to discover in a disciplinary procedure suspension conditions being set out in the way that one sees in Regulation 10. As the court appreciates, there then has to be a decision as to whether this is a potential misconduct or potential gross misconduct case. If gross misconduct, the matter goes to the investigator. And in relation to the investigator, again, there are further procedural safeguards. You have those, for example, at Regulation 15. Again, I don't take you through the detail of it, but the notice is given to the individual of various matters, the charges and so on. At the top of 204, the effect of Regulations 7, 1 to 3 and 16, that is to say, of the fact that the individual has a right to legal representation. Thirdly, under little h, the individual is cautioned, as might be the case in the criminal process. And then at 16 and 17, the individual has at 16, the individual has a right to object to the investigator, and at 17, of course, the individual is interviewed in the course of the investigation. The report then goes, as the court knows, to back to the chief officer for a decision as to which procedural route it should go down. And as the court knows, a key development as a result of the Taylor review was that there was now, as it were, a fork in the road, misconduct meetings for cases where what was being advocated was less than dismissal, hearings still where what was being advocated was dismissal. There's a dispute between the appellant and the respondent on the question whether this represented a move towards employment law. We say, yes, there was a level of informality in relation to dealing with matters through meetings and line management if there was something less than dismissal. But as regards dismissal cases, the level of formality continued in much the same way as it did under the previous regulations. You've got the point about the composition of the panel, Regulation 25(4), so I don't repeat that, and I've attempted to assist the court on the question of the independent member as they're described and how they come to be appointed. But by way of procedural safeguard, I also draw attention to the fact that Regulation 21(3), it goes to independence. There's a right to object, both either to the a person who is to be a member of the panel, or to the person who is, as it were, a clerk, as we would put it, a clerk to the court or clerk to the tribunal, the legal advisor.
And what are the grounds upon which such objections would be sustained?
Well, they're not specified. You can see.
But do we know what in practice?
Well, I'm afraid I couldn't give evidence even if I wished to on the subject.
What normally happens, do you know, Mr. Linden? In times past, there used to appear somebody who was effectively a presenting officer, or I hesitate to say prosecutor, but someone appeared to outline the case and call the witnesses in front of the chief constable. That's how the chief constable's inquiries were always conducted in the past. What happens now? Do you know?
I'll give my understanding, and if it's disputed, then obviously my learned friends will say.
If there's doubt, then we should know.
And it's important because of Lord Reed's point earlier yesterday about whether there's a list or not. What's being submitted is by my learned friend Ms. Monaghan is that effectively this is an employer inquiring into whether it wishes to dismiss an individual or not. The point we make in relation to that is, of course, both parties have legal representation in the course of this process right from the outset.
You say both parties.
Yeah.
The officer under investigation does.
Yes.
Who's the other party?
The authority that comes from Regulation 7, I think.
Regulation?
Regulation 7(4).
Ah, got it. Thank you. Yes.
So the appropriate authority may be represented at misconduct proceedings. And again,
the appropriate authority is the chief officer in,
that's right.
Yes,
in
exactly.
this case, yes.
Yeah. I mean, you may, of course, have presenting officers in some internal company inquiries.
Yes.
But I just wanted to know what happens with these.
Yes, I agree with my lord. Sometimes there'll be different degrees of formality, obviously, in the private law employment context. But what there will almost never be, and there have been arguments about this in relation to Article 6 of the Convention on Human Rights, is legal representation, that the process involves counsel or a solicitor on both sides, plus, as it were, a clerk to the court or the magistrates. And there's then the presentation of evidence through witnesses.
I think we're getting a bit into evidence here, aren't we? And so some of us might look at institutions with which we have previously been intimately connected, where that degree of formality is absolutely commonplace.
Yeah.
In universities, for example.
That was what I was thinking of. Yeah.
I agree. One can't say, well, here is the knockout point. That's what Trapp and Mackey's telling us. But I can say that you can see from the regulations that the parties have the right to be legally represented, and the case is therefore presented in that way. I can also say this, with respect, that you've seen from the decision of the panel the sort of task that it thought it was undertaking. And I don't say that the reasons produced are of the level of detail of an employment tribunal, for example, in some of the cases that the court will have seen. But if you have page 5152 of the core volume, what you will have seen from your reading is that you have essentially, as pursuant to the rules, the panel's decision as to the outcome plus a summary of reasons. And you've seen that it appears to have been a 2-day hearing. The composition of the panel is stated. And on 5153, you can see that the counsel on both sides are making what are described, if you have the fourth paragraph on the page, are making what they describe as submissions. They're as to the relevance of evidence which was proposed to be adduced. And you can see the panel in the next paragraph reminding itself as to the burden of proof. And you can see further down the page at Roman 3, the panel reminding itself of Regulation 3 of the regulation defining, albeit not with great specificity, concepts of misconduct and gross misconduct. So we do say that you can, I can't give evidence, but we do say that you can see from the document itself that this is not a case where the panel was informing itself as to whether the chief officer wished to dismiss P. It was a case in which the panel was receiving submissions on behalf of the chief officer and then on behalf of P, and applying what it understood to be the law to the evidence before it.
Incidentally, Ms. Linden, I see we do have at least 2 authorities in the bundles which are concerned with the immunity of judges rather than witnesses. One's the Royal Aquarium case,
Yes.
which is in bundle 12, tab 141, and then that's approved by the Privy Council in the O'Connor case, which is volume 11, tab 135, Lord Atkin. And those are both discussed, particularly to some extent by Lord Diplock, but more by Lord Fraser in Trapp and Mackie.
Oh, yes.
I think the impression from a quick reading is that they pay quite a lot of attention to the degree of similarity between the tribunal in question and a court of law in terms of the composition of the tribunal and the sort of procedures that it follows.
Lord, yes. My lady, may I answer Lord Kerr's question about whether you have a finding of guilt followed by mitigation on the basis of my instructions, or only in the sense that
Well, it looks fairly clear from the account of the hearing as to what happened.
Yes, in this particular case, because the facts were not in dispute, the question was characterisation of the facts and or sanction.
Well, there were 2 questions, weren't there? One was how were those facts to be characterised?
That's right.
And secondly, what was to be the consequence thereof? But there clearly were submissions made in mitigation of the seriousness of the conduct complained of.
Yes, indeed. I thought I understood Lord Kerr to be asking the question, well, is it like a criminal court where you get a finding of guilt followed by submissions on sanction? And my answer to that is, in the typical case, yes. May be dealt with at the same hearing, but they come, this is our decision, submissions on mitigation. It was rolled up in this case, as you've seen, because the facts were not in dispute.
Well, and the character evidence, if that's what you should call it, was given, unsurprisingly, on the principal issue. Yeah.
This is a pro forma, isn't it? With various headings.
Looks like it, doesn't it? I think. Yes.
It must be. Which include a mitigation heading. But what,
If I can then come back to the procedures themselves and pick up a couple of additional points. So you've seen through Regulation 21, the officer served in effect with a case against him or her. And then Reg 22, you can see what is required of the officer on receipt of such notice. And I draw attention, in particular to Regulation 22.2, they have to, as it were, plead to the allegation. They have to plead to the characterization of the allegation. And if they don't accept what's being said against them, they have to say what they dispute and their account of the relevant events and any arguments on points of law that they wish to be considered by the person or persons concerned conducting the misconduct proceedings. And they also have to give disclosure of any evidence they rely on, plus the list of witnesses. And again, I can't say, well, here's the knockout point, but in terms of the legal flavour, the court will have noted the similarities between that process and the defence case statement in the criminal process, and also similarities between the process of case management in the courts and this particular aspect of the process. As to the powers of the panel, you can see at 23 a power to compel witnesses in where they are police officers. That's 23.3a, and a power to give notice to other witnesses that their attendance is necessary, at least as regards serving officers, therefore similar to the witness order procedure.
well, that would be possible whether or not there was a regulation, wouldn't it? Because police officers are a disciplined force and they're bound to obey lawful orders.
I accept that. But it nevertheless is part of the overall picture, and you've seen obviously that the question whether witnesses can be compelled to attend was influential in Dawkins.
Same as Dawkins.
I draw attention to it also. Ms. Monaghan says, well, everything's getting less formal in the 2008 regulations. In fact, compulsion of officer witnesses was introduced, at least by way of regulation, for the first time in 2008. You can see, if you be good enough to go to 24.2, detailed provisions about extensions of time, and you've already picked up that there are time limits set. Again, I don't say, well, that's the end of the case, but if you look at the way that it's phrased, if there's a power to extend time if it's considered that it would be in the interest of justice to do so, and I say no more than that adds to the legal flavour of the process. One wouldn't, again, typically expect in a private law employer explicit references to the interests of justice in the course of a disciplinary procedure. There are then provisions as to interveners. You've seen it.
Might refer to the interests of fairness. They might refer to the interests of fairness.
I agree. I mean, I'm never going to be
less likely to use the word justice. I agree.
I'm never going to be able to say to you, well, there are absolutely no similarities whatsoever between this and a private law disciplinary process, because, of course, in a private law disciplinary process, a representative of the employer is trying to make a decision about a particular case and trying to do so fairly. If you've got 212 Regulation 30, provision for the participation of the IPCC where the issue arises from a complaint by the public, and at 2A to be for the IPCC to be represented by a relevant lawyer, and for them to sub-rule 3, provision for the investigator to attend and be available to answer questions, and then below that at 31 for the complainant to attend. Now, I draw attention to that again for limited purposes, some analogy with interveners, but also Ms Monaghan quite rightly drew attention to 32.1 that the proceedings must be in private, at least under the 2008 regs. But of course there was a degree of letting the public in where the public were particularly concerned because the matter arose from a complaint by a member of the public. You've seen at 34 the various powers of the, in relation to the procedure in the misconduct proceedings, including powers or rights to question witnesses, arguments about documents, admissibility of documents, and so on. But I did also want to draw attention to provision about inference drawing, which you have at sub-rule 10. So it's, again, by analogy with the criminal law, failure to mention facts when questioned, I'm putting it in very broad terms, may support an inference. And you've got at sub-rule 12, 34.12, where this paragraph applies, the person or persons conducting misconduct proceedings may draw such inferences from the failure as appear proper, which again I merely submit adds to the legal flavour.
Once you've got a caution, you've got to address the question of whether that's going to apply or not, haven't you?
Exactly. Exactly. But it's what I'm obviously seeking to highlight is it's quite a closely circumscribed by law, in brackets, process in terms of how the decision maker goes about their task, including legal concepts of the interests of justice, pleading points of law and factual disputes, provision as to when you may or may not draw inferences, and then, as you've seen at 14A, specific provision as to the balance of probabilities. And as we submit in our case, in the ordinary employment context, the decision maker on a dismissal case doesn't have to apply any particular standard of proof in reaching their decision. What they have to be able to do, if it comes to an unfair dismissal claim, as the court knows, is prove what their belief was as to the conduct in question, prove that they had reasonable grounds for that belief, and prove that they carried out a reasonable investigation. Lastly, at 15, at sub-rule 15, not lastly, but at sub-rule 15, I just draw attention to that provision. Ms Monaghan mentioned to you that there can be majority decisions, and the chair has a casting vote whether it's a panel of 2 or 4. But going to the question of agency, which we'll be addressing in due course, the panel is required to act as a collective body to make its decision and not to declare whether it's taken the decision unanimously or by a majority. So in the putative case, the statutory instrument doesn't enable, for example, an individual to say, well, I want to sue the 2 who voted against me, but not the 1 who didn't. It is a collective process. They make the decision, in effect, that we would submit as a body. You've seen that there's then provision at the bottom of at rule 37 for a verbatim record of the hearing, just as in a court, and then notification of the outcome, the duty to give reasons. Again, I don't say that applies exclusively to courts, but you then have the result that we've looked at briefly in the core volume.
I'm sorry, where's the duty to give reasons?
36.1, summary of reasons.
Thank you.
I'll come back to our submissions on Article 6 in due course, but we in the light of that material, we do submit that the Trap and Mackey criteria, if that's not putting it too firmly, are satisfied in relation to the disciplinary panels. And firstly, it's not in dispute that they're recognised by law, but obviously we seek to go further and say it's highly significant that they're set out by way of statutory instrument. Secondly, as to the nature of the question, we submit that the panels are deciding the sort of question that courts or tribunals may decide.
Can I just ask you about that? I mean, courts and tribunals decide an issue between parties.
Yes.
Do you say there's an issue between parties here?
My Lord, yes. I say that the effective position is that the chief officer, through her counsel, is advancing the case for dismissal, and the officer, through his or her counsel, is disputing that case as a matter of law and a matter of fact. And the task of the panel is to decide or reach a decision.
Well, what happens if the appropriate authority does not choose to be represented? There's a discretion under 7.4.
I'm taking instructions on that. Shall I continue with my submissions and come back to you on that? Or?
Yeah, yes.
But
Is the appropriate authority which brings the proceedings, it's certainly alleging conduct, and presumably it is arguing that it is either misconduct or gross misconduct. Is it arguing for any particular sanction or outcome?
My Lord will appreciate that by definition they're there because what's being argued for is dismissal, but it may be that
does that necessarily follow?
Well, the reason why it's gone to a hearing is because it's considered to be a case for dismissal.
It goes to a hearing where and it must go to a hearing where there's an allegation of gross misconduct such as could justify dismissal. Is that right?
Yes.
And the trigger under Regulation 5 is that an allegation comes to the attention of an appropriate authority. That's what sets the ball rolling.
Yes.
So it's not as if unless, from what I've seen so far anyway, it's not clear that the appropriate authority is, as it were, a prosecutor here.
That's different.
Indeed, may not be committed to the allegation at all, but is aware that there is an allegation, and in consequence establishes a committee to investigate it.
Yes.
Well, obviously, Regulation 5 refers to the beginning of the process.
Yeah.
It may be that the allegation comes, as it were, internally from an officer or from a member of the public, and that's what begins the process. But by the time, in answer to the question you asked, what I'm told is that they're not aware of any case where the officer hasn't elected to be legally represented, and the chief officer hasn't elected to do so.
But did I understand your earlier answer to indicate that a preemptive position is taken by the appropriate authority as to whether it's going to seek the dismissal of the officer?
I've got to be careful about the evidential point.
I wonder if you're right about that, Mr. Linden.
Which part, my Lord?
Well, that's the impression I got from your earlier answer. It may not be the correct impression, but it seems to me to be quite an important question.
Yes.
I mean, if the appropriate authority preemptively decides to elect for a hearing designed to establish gross misconduct with a view to dismissing the officer, then I think that that is quite important.
Well, it's been described
Because
as
it rather lends support to Ms. Monaghan's submission that what we're about here is not an investigation into the circumstances of the case, but as to whether or not the preconceived position of the appropriate authority is one which can be stood over.
can be stood over, my Lord.
In the sense that if the appropriate authority decides in advance, well, from the information that I've received, this is a case for a gross misconduct hearing and for the dismissal of the individual concerned. That's rather different from saying, well, I'm going to charge you with an offence and we'll decide whether the offence is proved and if it is proved, what the appropriate sanction is.
Yes. Would you bear with me?
Yes, I suppose.
Definition of gross misconduct.
So what my instructions are that the point when they refer, obviously, because they've got to make a decision about whether this is or is not proved as a gross misconduct case, they're clearly going down the dismissal channel. The role, as you've seen in our case, is described as prosecutorial, which, of course, the court will appreciate means that the role of the prosecutor is slightly different to the role of the civil advocate. And what I'm told is that a decision will be taken as to what as it were, the prosecuting counsel is saying the case supports. So there may be cases where they're saying it's clearly a case of gross misconduct, it should be dismissal. There may be cases where they're saying that and or it's misconduct, but are saying, but the mitigation is very strong. We're not advocating dismissal. Those are my instructions. But
In other words, it will depend on the case.
It will depend on the case, and Mr. Crozer will kick me not for the first time if I'm wrong, but they do advance a case as to what the outcome should be.
I wonder about that, Mr. Linden. If that's the practice, it's changed, which it may have done. But don't forget that traditionally English prosecutors do not address penalty.
Yeah.
I know that's changing as well, but traditionally they don't.
I'm told that is what they do at the hearing.
They do, okay.
Yeah. Of course, if one looks at this from the point of view of those periods in time when the actual decision was taken by the chief officer,
Yes.
the analogy with the prosecution simply doesn't work because the chief officer may be either saying, I've learnt of information which, to my mind, means I ought to be sacking this person, but I need a proper, fair investigation as to whether it happened and whether I'm right. So there could be that. Or the chief officer could be saying, I definitely think that I should be sacking this person. Whichever the chief officer is doing in those circumstances, it's not analogous to a true lis inter partes because the chief officer is using the process partly for his own protection and partly for the officer's protection and partly for the public protection, all of those things, in order to reach the right decision, but it's his decision. So it only becomes more like a lis inter partes when the decision is actually taken by the panel. Up until that point, it's really very difficult because, after all, he's not independent of himself.
That's right, but forgive me. At the time when the chief officer took the decision under the pre-2008 regulations, and certainly if you go back to a time that I happen to remember, when the chief officer was making the decision, he was not making it on the basis that he was considering dismissal. He set up a tribunal of himself, and somebody appeared to prosecute and somebody appeared to defend. There was a shorthand writer, every single word was written down.
And the burden of proof was beyond reasonable doubt, wasn't it?
And indeed, proof has had to be beyond reasonable doubt. But that's all history, from what you're telling us.
Under these regulations, there's the whole thing starts with the allegation coming to the notice of the chief officer, but he then has to consider whether, if proved, the allegation would amount to gross misconduct, and if so, he then has to appoint an investigator, doesn't he, who carries out an investigation, submits a report, and the chief officer then has to decide whether there is a case to answer. And if there's a case to answer, he then establishes the panel.
Oh, yes.
So he's, well, and it rather looks as though in terms of regulations, all he has done by the time he establishes the panel is to conclude that there is a case to answer.
Yes, that's what my instructions emphasise. At the time of the hearing, counsel for the CEO will put a case, and correcting myself, it won't necessarily be a case for dismissal.
Mm-hmm. Well, if that's right, I mean, if your answer to my lord is correct, that means that the appropriate authority, the senior officer, whatever, chief constable or whatever, he remains agnostic at the time that the disciplinary panel is instituted. If he's only deciding that there's a case to answer, he hasn't committed himself to any course.
Well, other than that, he's putting it into a forum where the issue is dismissal or not.
But if he does advance, or there is advanced on his behalf, a suggestion as to what the conclusions and outcome should be, yes, well, then he's at least formed a provisional conclusion. Yeah. But it's a provisional one.
Mm-hmm. Well, the difference is that now you've got a panel, whereas previously it was the chief constable himself who was the tribunal.
That's right.
Yeah. Thank you for that.
For that reason, he didn't declare himself in advance. He would have been in trouble if he had.
I'm going to go back to, sorry to say this, but I'm going to go back to 1965 when I addressed Mr. Bowen's argument about the effect of the Race Relations Act 1968. But I will be submitting that judicial proceedings immunity would have applied to the chief officer's decisions in those days. And that's because there'll be a presenting officer and for various other reasons, but I'll come to that. So back to my,
yes.
my summary of the, as to the nature of the listen to parties point, I made my submission that there is a case being presented on behalf of the CEO and a case being presented and there's an adjudication. As to the nature of the question, obviously I appreciate and the court appreciates that it's not identical to a decision, for example, by a GMC fitness to practice panel, where the issue is the broader question of whether they should be able to practice their profession, and the court discussed that yesterday. But in my submission, neither is it at the other end of the spectrum, where the only question is, should you be employed by this particular employer, for the reasons I've given, essentially that there are a number of different dimensions to the decision, including the public interest element, which is why it's governed by statutory instrument. As to degree of similarity, in my submission, there is a substantial degree of similarity between civil / criminal court process, and I submit obviously that this leads directly to the determination of civil rights, in particular the right of the individual officer.
But what about the
constable?
What about the fact that on your analysis, one of the parties to the proceedings appoints the panel that adjudicates between the parties?
That would, I accept, go to independence in relation to Article 6 of the Convention. Mm-hmm. But in my submission, it doesn't alter the judicial nature of the body. Everyone is acting under statutory instrument is the answer that I give to that. Okay. And I noted as I went with you through Lincoln and Daniels and Rokesby, for example, and Addison and Crocker, that again there's a basis for saying that there's a lack of independence in relation to those particular bodies too. Those are my submissions on the 2008 regulations. May I deal briefly with one of the points taken against me in relation to anomalies, and that point, there are various, but this is one of them. That point is that under the 2012 regulations, as you've seen, there was a change in the composition of the disciplinary body in relation to senior officers as defined, and the decision as to sanction was taken by the chief officer. My submissions in relation to that point are twofold. One, the chief officer would not be liable for the decision of the panel relating to that senior officer as to whether they were or were not guilty of the offence charged, and that's the issue in the case. If they had discriminated, would the chief officer be liable? And my submission is no. But in any event, I submit that the chief officer in that case is also protected by judicial proceedings immunity. You will have seen in the regulations that the chief officer has to hold a further hearing, which is subject to the provisions that we've just been through, in broad terms at least, relating to the panel hearing. Now, in support of that second submission, can I just remind you of the Bennion case, which you've got in Volume 7, tab 88, 2095.
Case.
Sorry, tab 88. The court will recall that that was a case where judicial review of a disciplinary decision by a chief officer was applied for on the basis that the chief officer should have remitted the matter to another chief constable pursuant to regulation of 14 of what were then the 1985 regulations. And it was being argued that he had not conducted a fair hearing by virtue of his refusal to remit. The passage I wanted to draw attention to is that the Court of Appeal at paragraph 23, 2100, page 2100, made the observation here in the context of the chief officer making the decision that they plainly involve a quasi-judicial process. They must be conducted fairly. It's expressly provided that they must disqualify themselves if they have any interest in the outcome of the proceedings, which does not arise from his office and the responsibilities vested in him as chief constable. So in my submission, it's not an outlandish argument to suggest that the chief officer making certain of the decisions that the chief officer has made over the years under these disciplinary provisions is performing a quasi-judicial function and therefore protected by judicial proceedings immunity. My Lords, my Lady, those are my submissions on issue 1.
Isn't there another anomaly suggested referable to constructive dismissal?
My Lord, yeah, there are various anomalies as I observed. Yes, constructive dismissal. It's being said, well, why would it be permissible to allege discrimination in relation to constructive dismissal, but not in relation to the decisions of the panels which actually decide to dismiss? And my answer to that is because the statutory instrument provides that the panels make particular decisions in relation to particular issues, and if I'm right, they are protected by judicial proceedings immunity. As far as constructive dismissal is concerned, based on actions outside that judicial proceedings immunity, then I accept the claims can be brought. Indeed, I was pointing that out by reference to the Singh case, that anything that's going on outside the limits of judicial proceedings immunity may be the subject of a claim. So I accept one could say, well, that's a bit surprising, but what I submit the court should say is, well, it means that there is meaning to the Equality Act when it refers to the ability of police officers to bring dismissal claims, or police constables to bring dismissal claims. Probationary constables can bring those claims. It's said it's an anomaly. I say, well, it's a decision advisedly made by Parliament that probationary constables are outside the statutory, the panel regime. Similarly, constructive dismissal claims can be brought. So our submission doesn't empty that part of Section 39 of any meaning. Now, as regards issue 2, as the court appreciates, ultimately the question is one of construction. We submit, obviously, informed by the fact that the panel enjoys judicial proceedings immunity. So we put the case in two overlapping ways. That one, as a matter of construction, Section 42 doesn't give officers the right to bring claims against panel members, and or, if it does, those claims are barred by judicial proceedings immunity. I accept that those, essentially it comes to the same thing. There's a difference as a form.
Against panel members and or against the appropriate authority?
Well, the claim can be brought against the appropriate authority. That's why I was...
Well, this claim has been brought against.
Yes, exactly.
Yes.
So that's why I made the point about what I suggest is the issue. That the issue is about the personal liability of the panel member. So the claim, and I accept that in the context of 2008 regulations, the submissions are not particularly attractive, because I am effectively submitting, yes, you can bring your claim against the chief officer, but it will fail if what you're alleging is discrimination against the individual panel members. So you can allege constructive dismissal. You can bring a claim as a probationer. You can bring it, but it will fail because the decision is made by panel members, and you're seeking to fix the chief officer for liability, with liability for their acts. Now, we've set out our case, as you may have seen, perhaps too comprehensively in paragraphs 43 to 79, and therefore I'm going to, if I may, I'm just going to mention the points rather than developing all of them in any great detail. It's 5028, it's core volume 5028, if it will help you to have that handy. So I'm going to pause in relation to one or two of the points, take out others of them simply.
Your discussion in 84 to 79, I don't think addresses the EU issues.
Sorry, my lord.
I don't think you address the EU issues there, do you?
No, I'm going to come on to those issues 3 and 4. I'm prosaically working through from 1 to 4.
Fine.
Obviously, I've got to. If I fail on the domestic law construction of Section 42, then you won't need to determine the third and fourth issues. First point, we submit that the onus is on the appellant to establish that they're within the Act, given that the Act doesn't provide a general rule that all discrimination by whoever is unlawful. Second point, if we're right on issue 1, they are contending for an exception to a general application of JPI. Third point, again, I don't say that any of these points is a specific knockout at this stage, but we note that Section 42 is a deeming provision, and we draw a contrast between the nature of Section 42 and other provisions in the field of work, which you'll be aware of. For example, the provisions dealing with partnerships, LLPs, and barristers, and so on. Where what you get is effectively a code for that particular sector of the economy, which specifies who may be sued in respect of which acts. The approach under Section 42 is somewhat different. And again, painting a picture of, rather than adopting knockout points, we say that it tends to support our approach that the construction of Section 42 is rather more, or the scope of Section 42 is rather more limited. The fourth point, we draw an attention to the fact that the statutory procedures governing police discipline are not a forgotten corner of the legal empire. You've gathered already, they're highly complex, but also they've been visited and revisited over the years. Again, we don't say, well, that's the end of the matter, but we do say it makes it more plausible that, as we submit, Parliament intended that remedies in respect of, or complaints in respect of decisions taken under those procedures should be dealt with under those procedures. Fifth point, we submit that even without the Heath and the Lake decisions, Parliament must be taken to appreciate it that these procedures would attract judicial proceedings immunity in any event. And therefore rely on the fact that there has never been any disapplication of judicial proceedings immunity at any stage. Sixth point, perhaps more cogent, we obviously rely on the fact that the application of judicial proceedings immunity to the 1985 procedures was then made explicit in the Heath case. And we rely on the principle that Parliament would normally be presumed to legislate with knowledge of the case law. Now, by way of footnote in relation to the chronology, of course, Heath was handed down on the 20th of July 2004, and the Taylor Review reports in January 2005. One doesn't know whether they considered Heath, one doesn't see reference to it and so on, but certainly there was the opportunity to do that. Next in the chronology, the Lake decision. A second decision of the Court of Appeal, this time in the context of whistleblowing, where, as you've seen, the Court of Appeal unhesitatingly accepted the point that the decisions of the panel couldn't be impeached. As you've seen, Lake turned on the fact that the chief officer could review the decision of the panel. And we accept that we couldn't say that that review decision was protected by judicial proceedings immunity. But we otherwise submit that Lake has correctly decided. Now, of course, my learned friends say, well, how can it be the case that the position would be different for whistleblowing claims as compared with discrimination claims? And our answer to that is, firstly, it isn't different. We submit that the same answer should be given in relation to the decisions of panels, the answer given by the Court of Appeal. But that even if you disagreed with us on that or rejected that submission, doesn't follow that the result should be identical as between, one sees the force of the point, that why would there be an ability to sue the panel in relation to whistleblowing issues, but not in relation to discrimination issues. But of course, that, as a matter of logic, that doesn't necessarily follow. Parliament may have decided that because of the specific public interest nature of the whistleblowing case, that claim should be available by way of limited exception in relation to judicial proceedings immunity, but that no exception should be made in respect of any other claim. You then have, as you know, this next point, the 2008 regulations enacted, and obviously that then is against the background of two decisions of the Court of Appeal saying that the decisions of the panels can't be impeached because of judicial proceedings immunity. Is there any sign in the 2008 regulations that Parliament disagreed with those conclusions? In my submission, quite the opposite. And the 2008 regulations actually did away with the review power, thus making the position in relation to the position more stark, not less. And as I pointed out, features were added which support the judicial proceedings nature of the panel's process, including coercion, the ability to compel witnesses to attend, admittedly if they're police officers and so on, and the ability to appeal to the Police Appeals Tribunal. Now, that was, as it were, on the disciplinary procedures side of the equation. But we draw attention, if you have paragraph 61 of our printed case, 5034, to the fact that it is not as if the only legislative activity was on the disciplinary procedures side. There was also a good deal of activity on the equality law side. And I don't propose to take you to all of the materials that we refer to, but can I just draw attention to two of them? Firstly, in 2005, the Employment Equality Sex Discrimination Regulations, which are A1 tab 3, various changes were made, which we've summarised in our case, but I wanted to draw specific attention, if you have page 164, to the fact that a whole series of amendments were made to the Sex Discrimination Act in relation to, as it were, atypical working relationships, so I can put it in those broad terms. So you've got provisions relating to office holders, 10A and 10B. You've got partnership, if you have 167, partnerships, trade unions, qualifying bodies, vocational training bodies, employment agencies, assisting persons to obtain employment. Pausing there, of course, the next section is section 17 of the Sex Discrimination Act, which have been considered by the Court of Appeal in Heath. It's striking there's no amendment to section 17, and the amendments continue with clergy, relationships which come to an end, educational establishments, and so on. I make in my submission the obvious point that here you have regulations enacted in September 2005, so more than a year after Heath had been handed down. One is proceeding on the basis that Parliament must be presumed to know the case law. Parliament here, in order to bring sex discrimination law, which had been specifically considered in the Heath case, into line with the European law, is making a whole series of amendments in precisely the area where one would have expected some consideration of the position of police officers if there was any concern about the scope of the equality legislation and whether it sufficiently protected them. And yet one sees no attempt to reverse Heath. My lady, the other, we've mentioned other pieces of legislation in our case. I don't take...
I mean, would it be in the power of the Secretary of State in regulations like this to use your phrase, reverse Heath?
But to make clear that, for example, the decisions of disciplinary panels would give rise, were potentially capable of proceedings, in my submission, yes.
Well, it actually inserts new provisions into the Sex Discrimination Act. It must be a Henry VIII case.
Sorry?
There must be a Henry VIII clause.
Well, it's done under the European Communities Act,
Yes.
isn't it?
Oh, I see. It's, of course, yes. Yes.
So I don't think it's
The biggest
suggested...
Henry VIII clause in history.
All right.
I don't think it's suggested that, well, it wouldn't be feasible to do it by statute.
They could have done it. There wouldn't have been any need, of course, at this stage, because this is 2005, when the decision is being made by the Chief Constable, and you've got Section 17 of the Sex Discrimination Act, which enables disappointed complainants to bring an employment tribunal case against him. Haven't you?
You've got you've got at that stage an ability under it was 99 regulations and the 2004 regulations to make complaint about the chief officer's decision on the review.
Yes.
But that's why there are lots of reasons why I do this, but why I press the point that the issue is the personal liability of the panel members.
No, I understand that.
And there are lots of reasons why I say that.
A remedy at
But
this stage.
yes, but in this connection, what you'd have therefore is, yes, just as in Lake, a claim could be brought against the chief officer for rejecting an application for a review, but the chief officer would likely have a very good defence, because he would say, well, the panel has made these findings against you, and I've simply relied on those findings, and nothing in that process would involve the potential for liability on the part of the chief officer for the decisions of the panel members,
So I've got the same problem.
or liability on the part of the individual panel members. The only other piece of legislation I want to draw attention to, specifically, because I don't think we refer to it in our cases, in 2006, the age equality regulations were enacted. My lady, if this, for your note, they're in volume A16, tab 222 at supplementary MS17. I don't invite you to turn them up, but Regulation 13 dealt with the position of police officers in relation to age discrimination claims. And again, I make the point, presumably alive to the Heath case, but no attempt to amend the legislation or to make clear that panel members could be sued. Next, chronologically, as you appreciate, you have the Equality Act. And in answer to my lady's question about whether it's technically a consolidation statute, paragraph 64 of our case quotes what was the avowed purpose of the legislation, in other words, to harmonise and to strengthen equality law. And we've given you, by way of helpful summary, paragraph 12 of the explanatory notes, which set out the areas in which there'd been strengthening of equality law. And that's at Annex 2. I don't need to take you to it because you've seen it. It's 506A. So clearly, as the court appreciates, the 2010 Act was the result of a very lengthy and detailed process and consultation with the various interested bodies, including the Commission. There were decisions that areas of the law needed to be strengthened. Plainly, this was not one of them. And my learned friends are not submitting that the Equality Act changed the law. The dispute between us is as to what the law was. Now, we add that paragraph 66 of our case, that it's not as if the Equality Act simply copied out, as one sometimes sees, the legacy provisions, so, paragraph 66, we highlight the point that there were some changes made. I don't dispute the statement that the aim was to replicate the previous provisions, but the terminology was changed in various respects. And I'm not saying there you are, the law was changed by the Equality Act. All I'm submitting is thought was given to Section 42 and in what terms, and as I submit, thought was given to that question against the background of Heath Lake and the various other points that I've been making. So we do submit then that there's a powerful body of evidence that the Equality Act in Section 42 was not a provision intended by Parliament to enable police officers to sue panel members. On the contrary, the position in law was endorsed by Parliament through the enactment of Section 42. Now, as to addressing some of my learned friends' arguments dealing with that submission, their arguments that it should be construed according to their case, we are criticised for taking a new point. I'm not going to debate whether that criticism was sound, but what I do note is that the Commission identified at the time of its application, we've given you the references in paragraph 74 and 75 of our printed case, that the problem, as they put it, was that the acts of the panels were not the acts of the Chief Constable, and therefore, as a result, they advocated reading words into the provisions. And secondly, although obviously this isn't conclusive, it is striking that nowhere in the Commission's application, nor in their written submissions, is reliance placed on Section 109, as Ms. Monaghan does. It wasn't submitted by the Commission that Section 109 could be relied on because there was effectively an employment relationship between the Chief Officer and the panel, and or they were agents of the Chief Officer. And that's the position of the Equality and Human Rights Commission. Now, Ms. Monaghan has developed an argument that she can succeed, as I understand, under either heading. As to that, we covered the point to some extent in our written case. Paragraph 58, we've dealt with the historic position in relation to the introduction of the vicarious liability provisions. And Section 64 of the Disability Discrimination Act is obviously the example you're being asked to consider. But these provisions introduced at the beginning of the 2000s we accept, to implement European law, were introduced in effect to reverse the decision in Liversidge, as you've seen. That decision being that because there were no vicarious liability provisions, in fact, if you were harassed by a fellow Chief Constable, you couldn't bring a claim of race discrimination. The provisions, as you appreciate, do not provide or do not answer the question whether the individual is an employee or for these purposes or acting in the course of their employment, or whether they are agents. And I don't understand my learned friends to be submitting otherwise. But if the problems with submitting that they are employees in my submission are that they are not. They are, in our submission, discharging statutory functions under the regime that you've seen described and in respect to which submissions were being made, not acting in the course of their employment. Ms. Monaghan, no doubt with section 43 in mind, said that they were working under the direction or control of the chief officer. But in my submission, that isn't the position. The chief officer, through counsel, is presenting a case which the panels have to decide. And if they don't decide it the way the chief officer wants, there's nothing the chief officer can do about it.
Well, that's, of course, they're acting under, the police officer members are acting under the chief officer's directional control to the extent that they are part of the panel. It's a bit like judges, as you would say. You know, we act under the direction and control of the court because we're here. We might not have chosen to be here, but we are here. But of course, nobody can tell us how to decide this case. It's a rather similar situation.
Yes, I accept, because that was what the statute provides, that they're appointed by the chief officer. But that doesn't mean that they have the relationship with the chief officer when they're discharging these duties that an employee has with their employer. And then, of course, there is the difficulty of the non-constable members of the panel. Not such a difficulty, I appreciate, in the case of the HR person if they're an employee, but in the case of the independent member, as I understood it, Ms. Monaghan's answer was, well, they would be an agent. Now, as far as agency is concerned, you'll be aware that the Court of Appeal in Farrer decided, you've got it, I don't take you to it in view of the time, but it's volume A9, tab 104, decided that a police constable, in discharging their law enforcement functions in relation to the public, wasn't acting in the course of their employment, but they were providing services to the public and therefore susceptible to claims under section 20 in principle. In fairness, I mentioned Baskerville, A2 tab 17 MS 495, where the Court of Appeal held that one can't never say never, as it were. There may on the facts be an agency relationship where, for example, in that case, it was alleged that colleagues of the claimant were racially abusing her. Then you have Yearwood, if I can just take you to that case. It's A2 tab 25. MS 623.
I'm sorry, Mr. Linden, number?
My lords, MS 623.
623, thank you.
This was a case where the agency route was attempted. If you have the head note at 623, various cases were being examined, and I point out in fairness that the issues related to the actions of the investigating officer and the supervising officer under the 1985 regulations.
So not the panel.
That's right. The reason I pointed out in fairness is because the EAT said that they were not acting as agents, they were discharging their statutory functions. And one can see that the reply to this point might be, well, therefore Yearwood proves too much. Because if they're not agents, how can the panel be? But the effect is that you cannot, through the agency route, bring claims against people making decisions earlier in the disciplinary process. I'm drawing that to your attention in fairness. But in any event, the EAT examined the question whether those making decisions earlier in the process could be regarded as agents, and concluded that they could not be. And you can see the agency issue being addressed from 632 onwards. I don't read you lengthy passages from it. No doubt you'll go back to it when you reach your decision. But if you have paragraph 41, the next question to consider is page 635. The next question to consider is to consider whether the 1985 and 1999 regulations impose such an agency. In our judgment, they do not. The proper construction of these regulations is that the various officers within the police force are given responsibilities. Since in the 1985 regulations, the chief officer is expressly excluded from carrying out the duties of an investigating officer, he or she cannot delegate those duties. That's implicit in the 1999 regulations too. People cannot do through an agent something that they cannot do for themselves. Specific duties are placed on all of the parties. They apply directly and only, and so on. That, as you can see, looking at 634, was based on the proposition that the conventional approach to the question of agency should be taken under the regulations and indeed the equality legislation, that where it says agent, it means agent in the classic sense. Now, before I move on to Kemeh, which is a Court of Appeal approving Yearwood in that regard, can I then deal with the point about, as it were, the route through? I do submit that the individuals involved in the process cannot be regarded as agents of the chief officer, in part for the reasons given by the Employment Appeal Tribunal in Yearwood, but in part also for the reasons that I've given, that the chief officer is bound by the decisions of the panel rather than the other way round. Does that prove too much? In my submission, it proves that the agency route through Section 109 is not open. That drives Ms Monaghan back to the employee route. And in my submission, one can see the force of the point that those who are making decisions about investigations are asked to do so in the course of the disciplinary processes or acting in the course of their employment. I've made my submissions, however, that when one gets to the panel decisions, they're not doing that in the course of employment by the chief officer for the reasons that I've given.
I'm wondering, Ms Linden, if there's not a more straightforward approach which you might take here. Section 109, we can see what it says. Anything done by a person A in the course of A's employment must be treated as also done by the employer. Now, Section 109, obviously, if you ignore EU law, obviously doesn't apply to police officers because they're not employees. They're not employees of anybody, let alone of the chief constable or the commissioner. So in order to get around that, Ms Monaghan has to rely on Section 42. But Section 42, subsection 1, only applies, first of all, for the purposes of this part. Section 109 is a different part of the Act.
Yes.
But for the purposes of this part, holding the office of constable is treated as employment, but only in one limited respect, in respect of any act done by the chief officer in relation to a constable or to appointment officer of constable.
Yes.
So, I'm just wondering, if you're leaving EU law out of the picture, what Section 109 has to do with this?
Well, I'm grateful. That's the point, with respect, that I disavowed interrupting Ms Monaghan at the beginning of her submissions, and it may help if I explain why I disavowed it. As a broad point, it would involve, it would contravene the principle of regression, because I would in effect be arguing that the Equality Act produced a result less favourable for police constables than was the position under the legacy enactments. Why would I be arguing that? Why would that be the effect of my argument? Because under the legacy enactments, as you've seen, for example, Section 64A of the Disability Discrimination Act, the provisions had two limbs. One was to say that you're deemed to be an employee in respect of acts done by the Chief Constable, but the other was to say, in addition to that, for the purposes of the vicarious liability provisions, you are deemed to be an employee. It may help just to dig out section 64A.
I appreciate you're not running the argument, but how do you avoid it on the wording of the statute?
By saying that the provisions in Part 8 are ancillary provisions which inform the whole of the Act.
I'm not sure we've got the title to Part 8, but you're quite right. Part 8, prohibited conduct, ancillary.
Ah.
Section 64A. Sorry, Paul. Section 64A, where do I find that? Yeah, sorry. I thought it might be helpful just to quickly to look at. We got it there. It's not actually in there. Section 64 is missing.
No, it's volume 5, tab 61. No, sorry. It's tab 65.
So that's volume 6. Thanks. Thank you very much. My Lord, it's as you'll have heard, can't take the credit for this. It's volume 6, tab 65.
Regulation 25.
That's right. It's 15, MS 1518. So what you had, if you got section regulation 25, what you had in all of the legacy enactments introduced post in the early 2000s, as I mentioned, was a provision that you can see subsection 1, similar to section 42, and then a specific reference to, for the purposes of section 58, the vicarious liability provisions in the Disability Discrimination Act. The same applies. So that I couldn't have run an argument under the Disability Discrimination Act. Well, it only applies for the purposes of this part. And I don't run an argument that the Equality Act then markedly reduced the rights of police officers. Well, can I just reassemble?
So, I mean, are you arguing that Section 109 should be read as if it was in the same terms as the old Section 64A2?
Yes, I can't argue against that. So what I'm ultimately submitting, therefore, is that where one sees references to agency, one has to ask, can it really be said that the members of the disciplinary panel are agents of the chief officer? And when one sees references to those acting in the course of their employment, can it be said that the panel making its decisions is acting in the course of employment by the chief officer? And my submission is, the answer to those questions is no, because for all the reasons I've given, the legislation takes place against the background of judicial proceedings immunity applying, decisions by the Court of Appeal in Heath, that it applies to these very procedures, and then simply, and no sign at all of a desire to change that position under the Equality Act.
And to say that two of the three may be acting in the course of employment isn't enough.
Well, I add that point, that they act as a collective body, but I wouldn't accept that the two are acting in the course of their employment for these purposes.
You say 64A is confined to the kind of case where the superintendent or the chief inspector discriminates in the course of of ordinary police work.
Or more typically, because the Liversedge problem was a police constable. She was being abused, I think so, she was racially abused by her colleagues. And because there were no vicarious liability provisions,
Right.
the Court of Appeal held that, the Chief Constable was not liable for the acts of her colleagues. And these amendments corrected that position. It doesn't obviously exclude the possibility that the actions of the panel could fall within these provisions, but for the reasons I've submitted, I invite you to find that, as a matter of construction, that's not the position. My Lords, my Lady, the last point in this sequence is the case of Kemeh, which you have at A10, tab 131, MS 3205. I don't think I need to ask you to turn it up, but Kemeh is Court of Appeal Authority in, I think, 2014. Managed to get that right, 2014.
Sorry, what's the tab number again, please?
My Lord, 131, A10 131. I wasn't going to ask you to turn it up at this stage, but
No, just...
Yes, but it's Kemeh.
that's right.
Kemeh could be spelt so many different ways.
Sorry. It's Kemeh, A10 131 MS 3205. I said earlier that approved the approach in Yearwood. What I meant by that specifically is that the Court of Appeal held that where there's reference to agent, you apply the law of agency. There isn't some wider meaning in this particular context. They were not looking specifically at the position under disciplinary regulations. I mean, my Lords, my Lady, next point is in relation to the 2015 regulations. You've seen that those regulations now provide for the chair of the panel to be a person who satisfies the judicial appointment eligibility under the Tribunals Court and Enforcement Act 2007. And that they also provide that these hearings should be held in public, whereas misconduct meetings would be held in private. The appellants say, well, this makes no difference to the analysis. We also say this case turns on the position under the 2008 regulations. But obviously, especially this court will have one eye on the potential spin-offs of any decision that it reaches in this particular case. And the second point I make is that there is still no sign that Parliament intends that these types of proceedings be brought within the Equality Act on the basis that you can allege discrimination against the individual panel members. On the contrary, what one sees through the 2015 regulations is a parliamentary intention to make it even clearer that these proceedings are subject to judicial proceedings immunity in my submission. They're more legalistic and they're being held in public. Can I turn nextly to Mr. Bowen's submission, if I may say so, cogent submission, by reference to what the position would have been in 1968 when the Race Relations Act was enacted, and or in 75 or 76 when we had the Race Relations Act and the Sex Discrimination Act. And one understands entirely his point. Well, the law then would be that you could bring claims against panel members, and there's no intention to change the law, and therefore you should rule in favour of the appellant.
No, it would be the Chief Constable.
It's not against panel members, it was against the Chief Constable.
Yeah. Well, that is indeed my first point. That under the 65 regulations, for example, the issue of the personal liability of panel members didn't arise. My second point, I don't do this pejoratively, but just by way of shorthand, that in terms of the plausibility of the analysis, in my submission it's far more plausible that Parliament enacted Section 42 on the basis of what the Court of Appeal said was the law than it did so on the basis of what I would call the Bowen hypothesis, i.e. the hypothesis as to what the outcome would have been had the issue been argued in 1968. As a matter of statutory construction in my submission, imagining parliamentary draftspersons and MPs and so on and committees considering the case, in my submission it's far more realistic to suppose that they did so knowing of Heath and Lake rather than taking a view as to what the outcome would have been under the Race Relations Act 1968.
Is it possible they've just copied the previous act?
Well, that's why I've pointed out that they haven't. You see, they have the 68 Act. No one's saying was in the same terms as the subsequent legacy enactments. The subsequent legacy enactments start with Lim 1 and then have Lim 2,
yes,
vicarious liability added in the beginning of the 2000s, and then Section 42 actually doesn't simply copy it all out. It's clear that somebody thought carefully about how it was going to work and moved the vicarious liability provisions into Section 109, made specific provision in relation to specific areas of the force and so on. So it wasn't simply a matter of boilerplate copying out. But let's assume that they had done that. It would still be my submission that they did that knowing of Heath. And knowing of Heath and Lake, it would have been very surprising that they elected simply to copy out the regulations and therefore confirm the position, if actually what they had in mind was the opposite conclusion. So my second point is, indeed, that with great respect, the realistic approach to statutory construction is to work on the basis that they enacted Section 42 in the light of what the law actually was. Third point is that I would submit that in any event, judicial proceedings immunity would have applied in 1965. Now, I do that I'm going to make that submission fairly briefly, but we'll need to look at the 1965 regulations. But the first point I make is that, of course, it's very easy to look at the issue through 2017 eyes and with awareness of Jones and Caney and Arthur and so on, and other statements of judicial scepticism about judicial proceedings immunity. But of course, you wouldn't have been looking at it through 2017 eyes had the issue arisen in the 1960s. You would have been looking at it against the background of authorities like Lincoln and Daniel and Dawkins, which, as I mentioned, is why I took you to those cases, to show that at that time there was a pretty expansive approach to the sorts of bodies that were covered by judicial proceedings immunity. Now, secondly, if one then goes into the regulations, it's volume A5, tab 51. At MS 1255, you may ultimately conclude you don't need to decide the point, but if you do need to decide the point, then my submission, as I've mentioned, is that judicial proceedings immunity would have applied to the decision of the Chief Constable. And one of the ironies in relation to this part of the argument is, of course, Ms. Monaghan is submitting that things were highly formal in the past but became less formal. I'm disputing that. But I accept the point that in 1965 there was a formal procedure, and I do submit that it was quasi-judicial. And you can see Ms. Monaghan's highlighting differences in language in the 2008 regulations. But in 1965, you were certainly concerned with offences, disciplinary offences, and the investigation of charges, if you have 1255. You had provisions relating to investigating officers at 2.3 and as to their independence. Then, if you look at the heading personal explanation on 1256, you had the administering of a caution under 3A and B. You then had what's described as the formulation of the charges. And you then had provisions dealing with delegation, documents being supplied, questions in the discipline form to be answered by the accused. And at 7.3, power to order the attendance of witnesses. And at 8.1, the accused is ordered to, at the hearing of the case, underlined. And as my Lord Hughes was mentioning earlier, under 8.3, the case against the accused should be presented by a member of the police force other than the Chief Constable or Deputy Chief Constable. And you can see at 8.5 references to submissions being made, a verbatim record and so on. References under in relation to Regulation 10 to hearings in the absence of the accused. And then at 11, you can see references to cross-examination, 11.2a, and 11.3, references to giving evidence, presenting officer, cross-examining the accused, and then the decision of the Chief Constable. I'm not going to spend more time on the regulations, but if it's necessary for you to make a decision about what the position would have been in the 1960s, I would submit that the position would have been, the answer would have been the same as regards a claim against the chief officer, that he or she, in those days, of course, was conducting a hearing where a presenting officer put a case and there was a response. There was cross-examination and so on, there were charges.
With appeal in those days, I'd forgotten, but that's right, isn't it, 8.7, to the Secretary of State. And what actually happened was that he nominated a suitable silk to do it.
That's right. It's under the Police Act 1964. A process rather similar to the process in Trapp and Mackey, that there would be, in effect, an inquiry by way of appeal. Well, ultimately, that's all I propose to say on the subject of that argument of Mr. Bowen. Can I go then to various other arguments that feature, but take them quite swiftly, because we've set them out in writing. Mr. Bowen submits that, I think both parties, the intervener and the appellant, submit that by necessary implication, the claims can be brought against members of the panel. We dispute that for the reasons we've given, that the evidence shows quite the opposite. In relation to anomalies, I've already touched on that question. It's a question of how the anomalies arise, and my submission is they arise because of decisions made by Parliament in the disciplinary context. I've made my submissions about where the lines are drawn if judicial proceedings immunity applies, and of course I make the point that it's long been said that judicial proceedings immunity may have unattractive consequences. That was recognised in Trapp and Mackey, as you've seen, that the effect of the immunity imposed for public policy reasons is that there may actually be meritorious complaints and or wrongs which do not attract a remedy. Then there's a set of arguments in relation to common law principles, and I imagine that what my lady said to Mr. Bowen goes for me too, that if I can't succeed on my arguments so far, I'm unlikely to succeed on those arguments. My position is essentially, however, obviously a defensive position, saying, well, they don't make any those arguments don't make any difference to the outcome that I've contended for. On the proposition no wrong without a remedy, I've made the point that a consequence of judicial proceedings immunity is indeed that there may be wrongs that don't have a remedy. But in addition to that, of course, they assume that there is a wrong in the present case in the sense that the legislation provides for a claim, which then cannot be acted upon. But that's something that they need to prove, and both sides have made submissions on that. But in any event, of course, I submit that there is a remedy, and that's an argument I'm going to come to in relation to Europe. On the removal of jurisdiction, again, I say, well, that's, again, begs the question. Ultimately, the question turns on the construction of Section 42, on which I've sought to address you. And similarly, in relation to the principle of legality, I know the Commission rightly accepts that the principle of legality, that the judicial proceedings immunity would be engaged as a relevant principle in relation to the principle of legality. So, for the reasons we submitted orally in writing, I submit that that makes no difference to the outcome. Finally, Mr. Bowen's submissions on the INCO case, the notion that there's been a drafting error. In my submission, that there can be no conclusion that this is a drafting mistake somehow or other, despite repeated visits to the disciplinary procedures and repeated tweaking of the anti-equality legislation and plus a comprehensive act, that somehow a mistake has been made.
But you do seem to accept that there's been a mistake made in relation to Section 109.
I beg your pardon?
You do seem to accept there's been a mistake made in relation to 109.
No, my Lord, I'm not suggesting there's any mistake. I'm suggesting that what they did was recognising that the vicarious liability provisions were ancillary provisions which inform the whole of the Act. Rather than have them repeatedly, they put them into the ancillary provisions section so they would govern all of the other. I say they did that advisedly, not by mistake. And I've accepted the consequence of that is that Section 109 may be available as a route in principle, but I say it's not available on the facts in the present case. So I don't suggest any error was made. Okay. Well, ultimately, that brings us to articles, to the European arguments. As I understand those arguments, they essentially boil down to two issues. First, access to court. Is there access or sufficient access to a court for these claims to be adjudicated? Secondly, remedy. Is there an effective remedy?
I thought the basic EU issue was this: has the directive been properly transposed? And if it hasn't, what do we do about it?
My Lord, that is indeed one of the issues. I certainly noted that Ms Monaghan's said that it appeared to be saying that in a sense they boiled down to one question. But I think, if you don't mind my putting it like that, that there are ultimately two issues, although they go essentially to the same point. One is there sufficient access to the court? We say yes, there is. You have your hearing before the panel, you go to the appeals tribunal, and then to judicial review, and that satisfies.
Yeah, but the right we're talking about is the right not to be discriminated against.
Yes, I understand that.
It's not an argument about Article 6 of ECHR or Article 47 of the Charter. It's an argument about the directive.
Yes, I appreciate that.
Well, I think you've been discriminated against, but the outcome would be the same.
I'm sorry, but I didn't.
Supposing you've been discriminated against, but the outcome in relation to the disciplinary decision would be the same. What's your remedy then?
I mean, what if you've got a blatant act of sex discrimination? You know, that different verdicts are reached in respect of, say, a female officer from the one in respect of a male officer, and it is quite clear that this is because they were giving the woman more favourable treatment than the man. But the treatment of the man would have been the same, come what may. He's nevertheless got a complaint, hasn't he? But not about his dismissal, it's about the discrimination. I think that's my Lord's point.
Better put it, if I may say so, but that is the point.
Well, this argument obviously is being advanced solely in relation to decisions about dismissal made by panels. So the issue that the issue that the panel is, the question is, can the individual panel members be personally liable for discrimination? The panel members are only involved in the story because they are being asked to make a decision about dismissal or otherwise. And as you know, my essential answer to that is they have, through the appeals tribunal and the administrative court, the ability to have the act complained of, the dismissal, quashed and reinstatement ab initio.
On the face of a directive, they fall within the scope of Article 3, and therefore, if that's so, the directive requires there to be a remedy against them.
Well, there is a remedy in the sense that their decision is reversed by the appeals.
Sanction.
Well, sanction, my lord, I'm grateful to you for reminding from it, because I wanted to address that point. I mean, sanction isn't, I don't think Ms Monaghan intends so, the ability to, as it were, act in a penal way. She and I argued a case called Koppel some time ago, where we debated these sorts of issues. The principle is compensatory. It's not said, for example, that the problem with the Equality Act is that in employment cases you can't penalise the employer. You can only compensate the individual for their loss. So in my submission, it should be looked at in terms of remedy. But, Melody, I'm slightly... I'm not asking the court to advise me, but I had understood, Ms Monaghan would tell me if I'm wrong, that there was a complaint about access to the court, which I was going to address.
And remedy, of course.
And remedy, exactly. But don't I need to address both?
Well, it's a matter for you. You may think that I'm completely right and it isn't necessary. But subject
Somehow
to
that seems a bit improbable.
Improbable. It would have been wise, but it's improbable.
Just to be absolutely clear, if it's unclear, we say that there is a directly effective right to non-discrimination and an obligation to secure effective judicial control and sanctions within the meaning of the directive.
Yes.
And if Ms Monaghan's right, that cuts through everything else, including judicial immunity.
Well, I'm not following that point. Forgive me.
If EU law is hierarchically superior to domestic law,
Yes.
and EU law requires there to be a remedy for discrimination by disciplinary panels, then such a remedy, and assuming that's a directly effective right, an effect has to be given to it.
Well, I'm happy to deal with the remedy question first, then. Essentially, my argument is that there is an effective remedy, and I say that by reference to the Marshall case. If we can take that up in A16, which is the appellant's supplemental bundle. The court will be aware that Marshall was the case which raised the issue. If the remedy is compensation, can there be a cap on compensation and or should interest be awarded? The principles on which I rely are at paragraph 23 to 26, page 79.
Page, MS page?
MS 79, my lady.
79?
Supplementary.
Supplemental.
Yes.
Oh.
I'm so sorry, yes.
It's
Sorry.
tab 226.
Sorry, my lord, yes. Sorry.
Oh.
So, going back to von Coulson at para 23, what was in Article 6 doesn't prescribe a specific measure to be taken in the event of a breach of the prohibition on discrimination, but leaves the Member States free to choose between the different solutions suitable for achieving the objective of the directive, depending on the different situations which may arise. However, the objective is to arrive at a real equality of opportunity and cannot therefore be attained in the absence of measures appropriate to restore such equality when it's not been observed. The Court stated in von Colson, those measures must be such as to guarantee real and effective judicial protection and have a real deterrent effect on the employer. Such requirements necessarily entail that the particular circumstances of each breach of the principle of equal treatment should be taken into account. In the event of discriminatory dismissal, contrary to Article 5.1, a situation of equality could not be restored without either reinstating the victim of discrimination or, in the alternative, granting financial compensation for the loss and damage sustained. Where financial compensation is the measure adopted in order to achieve the objective stated above, it must be adequate, and it must enable the loss and damage actually sustained as a result of discriminatory dismissal to be made good in full in accordance with the applicable national rules. Now, I take my Lord's point about the use of the word sanctions, but I do submit that it's not the case that European law requires penal measures to be taken in relation to discrimination. I take the point, and as I mentioned, Ms Monaghan and I argued about it in a case called Koppel, that if you go down the compensatory route, there must be full compensation.
But full compensation for what? I'm afraid I haven't entirely understood your answer to Lady Hale's question. If there was discrimination in reaching a conclusion about dismissal, but absent the discrimination, she should still have been dismissed. Yeah. Is there still room for compensation?
My Lord, I accept that on my case, there would not be compensation, because in the employment tribunal, you might get compensation for injury to feelings. Going through the statutory instruments, what you will get is the act complained of reversed. So in the case of dismissal, you will be reinstated. And so my submission is that that is an effective remedy.
Now, of course, domestic law recognises a claim for injury to feelings caused by unlawful discrimination, does it not?
Yes, indeed it does. I don't dispute that.
Under EU law, the EU remedy has to be equivalent to the local one.
I'm grateful to you for reminding me of that point. Lord Reid raised the issue of equivalence as well. I, of course, accept that the principle of equivalence applies, but what I point out is that that principle bites in relation to a comparison between remedies for EU rights as compared with equivalent causes of action under domestic law. There's a case called United Road Transport against Secretary of State for Transport, 2013 IRLR 890, where an argument was put that a given EU law remedy was not equivalent to another given EU law remedy. And that argument was rejected, I think I'm right in saying, by the Court of Appeal, on the basis that equivalence is about equivalence with domestic law remedies for domestic claims.
But just to go back to your answer to my Lord Wilson, and who queried your answer to my lady's question, as I've understood your answer, you say, well, in the domestic setting, what happens is that you get reinstatement, and that's within the margin of appreciation, so to speak, of the national authority. But the premise of my lady's question to you was, if in a case, a particular case, it is established that there was discrimination, but that nevertheless the dismissal had to stand because of public interest considerations, what in those circumstances is the remedy for the discrimination.
Well, I do believe I've answered that, but I'll happily answer it again. You're therefore positing a case where there's been no financial loss, and the only issue therefore is injury to feelings.
Yeah.
And I've accepted that would not, compensation for injury to feelings would not be available through the statutory instruments. It would only be available through the employment tribunal. So I've accepted that a consequence of my argument is that there would not be compensation for injury to feelings in that case. But what I've said is, by reference to Marshall, is that Marshall clearly posits that you can make available either the remedy of reinstatement in such case or the remedy of compensation.
Well, we've gone down the compensation route, haven't we, in the Equality Act?
Well, on my analysis, we've gone down under the Equality Act a particular route, under the statutory instruments, which I say Parliament intended to apply in this particular case, a different particular route.
So your case is that the European imperative is satisfied because the remedy of reinstatement is available. It may not be granted in every case, but the mere fact that it's available is enough. Is that it?
Yes. And
Even though it cannot be brought about in fact. Its availability as a theoretical possibility is enough. Is that what you're saying?
Even if it fails, despite the discrimination.
Well, let's take this. I accept that it's a good example in which to consider the arguments that I'm putting forward. But what you're positing is a case where, for example, based on a racial stereotype, a conclusion was made that an officer had stolen. In fact, he had stolen. So, although the initial decision to dismiss was based on a racial stereotype, it was right that he should have been stripped of his office. Now, in that situation, obviously, he suffered no financial loss. In relation to his injury to feelings, a large part of the injury to feelings will have been caused by the fact that he was dismissed. And the panel has concluded that it was right that he was dismissed. So you're left, I don't use the word theoretical, but you're left with, it's not the dismissal I'm upset about, it's the fact that it was based on an assumption about me because of my particular ethnicity. And I don't say that's a totally trivial matter, but I do say that puts in context the sorts of objections to my arguments that rightly are being put to me by the court. I want to come to the Peterbrook case in a moment, but or perhaps after lunch, and I promise you I'm not going to be a great deal longer. But I do point out in my submission, importantly, that reinstatement is a very powerful remedy. In the employment tribunal system, it's only available in relation to unfair dismissal claims. It is rarely ordered. That the number that's frequently bandied about by advisors is 4% of cases, because of the need for a relationship of trust and confidence between employer and employee. And almost never complied with because the employer chooses to pay what's a relatively small sum of money for breach of the order. And as the court will be aware, much has been written on the advantages of public law remedies and the ability to quash decisions to dismiss and to reinstate. And in my submission, that is, or will be for many individuals, the best possible outcome, that the decision is reversed and they return to work. So it's not an insignificant point in my submission to argue that not only does the officer have the protection of the chief officer, as it were, being bound by a panel which reaches its decision in the way that we've described, but that decision of that panel can then be reversed by an appeals tribunal which reinstates them. Is that a convenient moment? I haven't got long.
Looks like a very convenient moment to me. Thank you very much, Mr. Linton. How much longer do you think you will be?
I'll have a word with Ms. Monaghan over the lunch time in German, but I don't think I may be shorter, but I don't think I'll be more than another 30 minutes.
Well, that would mean that you would be taking up less time than you were entitled to, as well as Miss Monaghan. This is always a good idea.
My lady, I wonder if that's so, if I needed a little more, perhaps 40 minutes rather than half an hour in reply, particularly as there have been some additional points raised, would that be acceptable? It may be that I can bring it within half an hour, and I'll endeavour to.
Yes, but we are obviously exploring an issue which hasn't really been fully explored before, so
I'm grateful.
and it's not without its complexities. We look forward to hearing from you again at 2:00.